Hi everybody, welcome to those of you in the room today, and welcome to those of you who are joining us online via YouTube. We're thrilled to have you join us for this event, which is part of the Curious Festival of Knowledge. A little bit of housekeeping before we get started. Please note that the RSE fire and safety and evacuation procedure is to assemble outside of the dome, leaving the building the way you came in, through the door there. Fire exit routes are on the slide there, but please follow the staff instructions. So it's the people wearing the purple hoodies and they're all waving enthusiastically at the back if we do need to evacuate. If the online audience have any questions, please type them into the chat and we'll have those read out on your behalf. For those of you in the room, you'll get an opportunity to raise your hand if you do want to ask a question towards the end of this event. So that is the end of the announcements that we need to make for the start. And it's my pleasure to introduce Professor Jan MacDonald, who was Professor of Drama at Glasgow University and Vice President of the Royal Society of Edinburgh. And she had a real interest in public engagement and also the reason why we're all gathered here, really the inspiration of us talking about this case in a little more detail. So, Jan, can I welcome you up, please, to give the overview and introduction?
Well, thank you, and good evening, ladies and gentlemen. The tale of the Ardlamont mystery fits very well into the mystery trope practiced by many of our most celebrated crime writers, Agatha Christie, P.D. James, Ruth Rendell et al. First, the setting, a large country house, a period country house, somewhat isolated from the communities. Secondly, a group of characters, most of whom know each other well, some even related to another. But there is an outsider, a stranger of mysterious and dubious background. Thirdly, a death, an apparent accident, but a rather suspicious circumstance. Now, missing from the formula at this stage is the brilliant but somewhat eccentric detective, you know, the character of Hercule Poirot, Miss Marple, Adam Dalgliesh, or Colombo. But be patient. The experts are here and will shortly enlighten you. So, to elaborate on that for a moment, the venue. Built on the Cowal Peninsula in Argyll, on the site of a pre-17th century castle, the house stands in 640 acres of land and dates from the first quarter of the 19th century. It is a symmetrical classical mansion of 2 stories with harled walls and a pillared porch. This was the property of the Lamonts. The name, incidentally, derives from the Norse lawman, paradoxical under the circumstances. The family was very powerful in Cowal, but was overtaken by the Campbells in 1646, and the Lamonts' 2 major castles at Toward and Ascog were razed to the ground. Ardlamont became their only real seat. In 1818, Major General John Lamont, who had fought in the Napoleonic Wars, resolved to build a house fit for my family on the most limited and frugal plan. In our eyes, it wouldn't, of course, be frugal. The Watson family bought the estate as a summer residence in 1894, just after the incident, but significant alterations were made. Now the house has upmarket holiday flats. They are bookable in case anyone's interested. The house is at the tip of the peninsula, facing across the Kyle towards Arran. The nearest village is Kames, which is about 5 miles to the north, and Tynebruch, which is just a little further up the coast. Access in the late 19th century was transport by train to Gourock, from Glasgow to Gourock, hence by Clyde steamer to Kames, that was the closest pier, or on to Tinnabrook, as I said, was quite close. To the southwest, some distance away, was the ferry terminal at Portavadie, whence travellers could reach Tarbert, Loch Fyne, and thence to Inverary, the county town and administrative and legal centre of Argyll. Inverary is, in fact, some 44 miles from Ardlamont, a journey by road and ferry. The distance is actually quite significant, so bear that in mind. Now, to the dramatis personae. First of all, there was Alfred John Monson. Alfred John Monson was born in 1860, the son of the Reverend Thomas John Monson and the Honourable Caroline Isabella Monckton, daughter of the 5th Viscount Galway. Now, actually, you see, these people are not kind of in the streets, as it were. One of the interests, I think, that was in this case was, in fact, that these were, let's say, at least local gentry. I mean, well, not local gentry, but, landed gentry. Monson's personal history prior to his stay in Ardlamont, if not murky, is a little confused. He was reputed to have been an Oxford graduate and appeared to hold a recognisable post in the colonial civil service. No record of his academic career exists, and his civil service career was surprisingly short. Inexplicably short, actually. On his return to England, he, first of all, took a post as a private tutor, and then, after a bit, opened a school in Yorkshire, which became quite successful, actually, but he was pretty profligate with his earnings and soon tired of teaching. In addition, the school buildings had rather an unpleasant habit of going on fire. This actually was quite lucrative because he got the insurance money. But eventually, the locals tumbled to the fact that something was seriously wrong. And in fact, he was in 1890 under a charge of fraud and bankruptcy. Right. I should say he got rid of this bankruptcy charge by putting everything in his wife's name. Now, to another important inhabitant, Windsor Dudley Cecil Hamborough, aged 20, extremely good-looking, athletic young man, destined for a military career, who had become somewhat estranged from his family. The Hamboroughs were definitely landed gentry, owning considerable property in Northamptonshire and also in the Isle of Wight. But unfortunately, Cecil's grandfather had been reckless with his fortune. This is a continuing thread. And his father, a retired major, was unable to improve the financial situation, being something of a spendthrift himself. Therefore, when the idea was mooted that prior to Cecil's beginning his professional military career, he should be sent to a private tutor, for fees of a mere £300 per annum, Hamborough père leapt at the idea, the sum being considerably less than the prospects of keeping a young man with extremely expensive tastes at home. The tutor was, of course, Alfred John Monson. Now, the broker of this negotiation was one popularly known as Todd, T-O-T. His real name was Beresford Loftus Tottenham, ostensibly a respectable financial advisor, but in fact a moneylender, or to put it bluntly, a Victorian conman. It was he who brokered the deal that got Monson out of bankruptcy, remember way back yonder, following the charges of fraud, and he who persuaded Hamborough to engage Monson as a tutor for the little Cecil. It was big Cecil, actually, he was a big man. Todd is, in fact, not even a footnote, really, in the story. As far as anybody knows, he was never at Ardlamont. But his ubiquity in the lives of the Monsons and Harbors lends some colour to their past history. Right. To recap, living in Ardlamont House in August 1893 were Alfred Monson, his wife Agnes, of whom I guess we may hear more, their 3 children, Cecil Hambra, and various domestic servants. Although I should point out that on the day of the incident, Agnes had taken the 3 children to Glasgow for a visit. But there was also A.N. Other, the mysterious stranger of detective fiction. And this man was definitely mysterious. He was known at this point as Edward Scott. Other names were Edward Sweeney or Ted Davis. Ostensibly, he was a nautical engineer, and the story was that Monson had met him on a steamer from Glasgow and invited him to Ardlamont to advise on the refurbishment of a boat to be purchased by Cecil. A bit strange there, but anyway. He was certainly present at the incident, but departed almost immediately afterwards, being given permission to go, actually, by the authorities, and henceforth successfully vanished. And I mean really vanished for a long time. Despite many attempts to discover his whereabouts by officers of the law, he failed to appear at all and ended up being officially outlawed by the authorities in Inverary. However, he did turn up several years later as a conjurer in an Edinburgh music hall. Now, before handing you over to our present-day experts, I should mention the fact that 2 pioneers of forensic medicine from Edinburgh University gave evidence at the subsequent trial. These were Doctors Littlejohn and Bell, and there is good authority that these were the models for Sherlock Holmes and Dr. Watson. Okay, ladies and gentlemen, I hope you're waiting with bated breath to hear these wise people speak.
Now, just before you go, John, and this is unscripted, and you don't know what's about to happen, but because there's a long history between you and I of wanting to put on this particular expose of Ardlamont, we got you a little souvenir of the Diet's evening's event. So this is a framed photograph of part of the newspaper coverage of the trial.
Thank you so much.
So that's for you.
Absolutely
It is
lovely.
my pleasure.
Oh, thanks
Not at
very
all.
much.
Not at all. Please come over here for a photo.
That really was unexpected.
It was. There you go.
We're good.
We're good.
Let Jan take her seat. Well, thank you all very much indeed for joining us this evening, both here at the Royal Society in Edinburgh and online, of course. I'm Penny Latin-Stewart, and in very close collaboration with the team at the Leverhulme Research Centre for Forensic Science at the University of Dundee, I produce and present the Inside Forensic Science podcast series. As we've been hearing so wonderfully from Jan, the story at the heart of the 3rd series is an utterly intriguing historic murder mystery. As true crime goes, it has it all. It has mishandled evidence, a chaotic crime scene, fraud, characters who vanish into thin air, and a main suspect who 1 minute you think must be guilty, and then maybe not guilty, and then must be guilty again. For the purposes of the podcast series, I have to say it was a fantastically difficult challenge. I've been doing this stuff for about 30 years now, making these kinds of programs, and it's probably one of the most difficult I've ever had to pull together, just from the point of view of juggling story with the sheer volume of information. Just out of interest, before we get underway, for the people who are here in Edinburgh, how many of you have heard the podcast series? Anyone? A few? This is great because it gives us a sense of how much we need to maybe give you the story. Even if you haven't heard the podcast series, how many of you are familiar with the Ardlamont mystery? Not many. Brilliant. Okay. Good luck. So, so for anyone not familiar with Inside Forensic Science, what we do is we dig up a historic case and then run the trial papers past contemporary experts to see what they make of it and get their view on maybe what's changed, what hasn't, and whether they think the verdict would be the same were the case to be heard today. So in this evening's event, we're going to talk about the Ardlamont case and discuss some of the forensic evidence which was presented at the trial. We're also going to hear a few excerpts from the podcast to help us tell a bit of that story. Now, on the panel, we have Professor Niamh McDade, Director of the Leverhulme Research Centre for Forensic Science at the University of Dundee. We have Rachel Sharp, who is a forensic firearms expert from the Scottish Police Authority Forensic Services. Now, Rachel and Niamh are two of the experts in this particular series, but we also have Alex Prentice Casey to lend his legal expertise. Alex is a senior advocate depute who's been responsible for the prosecution of a wide range of homicides, including the cold case murders of Rennie and Andrew McRae and Dr. Brenda Page, the trials of which were televised for the BBC Murder Trial series. And prior to becoming a prosecutor, he had extensive experience as a defence lawyer. He's also got previous experience as an expert contributor to the Inside Forensic Science series because he was one of our experts in our first series about the Jean Milne murder. Please welcome your panel. Niamh, we've heard quite a bit about Ardlamont already, but before we get really into the nitty-gritty, why this particular case? Why did you choose it for us to go and dive into?
It's a really good question, a good starting point, and good evening, everybody here in the room and online. The purpose, as Penny said, of the Inside Forensic Science podcasts are to look at old cases, and quite old cases in all of the three we've examined so far, to look at the evidence that was provided in those cases through the lens of the modern day and what we would do today in forensic science. Ardlamont was a particularly challenging case, as we've already heard, and we like to examine these cases pretty much from the crime scene, so the start, right the way through to the examinations of exhibits or materials that might have been recovered from that scene, right the way through to how that information was presented in court. And part of the challenge, I think, that this case provided that we wanted to just unpack a little bit and explore was really the relationship between the experts and that courtroom presentation or experience. And you'll hear a lot, I think, as we go through this evening about some of the challenges at the crime scene part of this. Penny's alluded to it already. It was a fairly chaotic crime scene visited by many, many people, all trying to do their bit and their best to help solve the mystery. And then we had a set of expert witnesses, and Jan mentioned them. They were I suppose, the showstoppers of the day. And in Scotland, we had a number of particularly forensic pathologists who were certainly famous in Scotland, legendary across the UK, and beginning to have that sense of the sort of almost celebrity type forensic expert. And they came to this particular case. Often they worked out of 3 universities in Scotland, so Edinburgh, Glasgow and Aberdeen, and all of them featured, as I said, the main players featured in this case. And they gave quite a lot of evidence. They really got stuck in, I would say, and they did a lot of work, including many reconstructions to try to tell the story of the events. And then they gave extensive evidence in the courtroom, often very technical and very complicated. So part of what we wanted to do with this trial, and why pick this one, is to unpack that provision of so much expertise to the triers of fact, the jury, that did that at some point become counterproductive? And how would we deal with that today? So that was one of the main reasons. So I'm so sorry we gave you such a headache. But I was going to say it was intentional. It wasn't really. But as things unfolded and we got more and more information, it started to show that, that intense interest as well in the media, that was certainly a flavour of the day back then. So that was why we picked this one.
And it did give me a headache. But so here's what we're dealing with. We've got 3 men. We've got young Cecil Hambro, his tutor, Alfred John Monson, and the man who is alleged to be the boating engineer called Edward Scott. They're out shooting rabbits on the Ardlamont Estate on the Cowell Peninsula. They split up. Scott and Monson, with one shotgun, go one way. Hambro, with one shotgun, goes the other way. And they're probably walking in parallel. Minutes later, a shot is heard. Let's get James Wright, the butler, to take up the story and tell us what happened next.
Scott was carrying rabbits, and he said that they had fallen to Mr. Hambro's gun. Neither of them had guns in their hands at the time. Monson said Mr. Hambro had shot himself. And when I asked, had he shot himself in the arm, he said no, it was in the head and he was quite dead. I asked him where the body was, and he said in the wood. I went out to look in the shrubbery. I could not find him and ran back and told Monson, whom I had left with Scott at the door of the dining room. He said, come and I will show you. I passed out with him by a door at the back of the house, past the stables at the back of the house. As I was passing the stables, I saw White, the gardener.
Monson said to me, young Hambro has shot himself. See and find something and bring him up to the house. I went and found a rug, which I took with me to the plantation, Monson leading the way. The body was lying upon the grass on the top of the old dyke. I looked at the body and I saw that it was dead. It was lying on its back, turned a little to the left side. There was no gun near the body, and Monson was not carrying a gun when I first saw him. I saw a wound on the back of the head, and there was a good pool of blood under the head on the ground. A small hole in the ground was full of blood. That was all the blood that I saw on the ground. The head was nearest to the rowan seedling, which I knew. We had taken the rug with us. There were other people who were helping. The people present were Stephen, the factor, Stuart, Carmichael, the elder Carmichael, the ploughman, and James Lyon, who had his cart. After placing the rug under Hambro's feet, we drew it below the body. It was lifted and placed in the cart and taken up to the house, round up by the offices and by the end of the wood. When we got the body to the house, we undressed it. I identify these clothes. The only blood I noticed on the clothes when they were taken off was a little about the collar. That, along with the blood at the head, was all the blood I saw. I don't remember if there was any blood on the rug when we took the body out of it. Monson wasn't present when we put the body in the rug. I don't know what became of him. He went away after pointing out where the body was.
So, we've got a death, and at this point, it was not treated as a murder, because Monson and Scott say it's a terrible accident. Hambro must have somehow tripped, and his gun has gone off, and he's managed to shoot himself in the back of the head. Let's pause for a second and think about, Neve, how that scene was dealt with and what struck you about how it was dealt with. We heard here he was wrapped in a rug, taken back, and actually, in an added point there, he was then washed and stripped of his clothes and dressed for the grave, even.
So I think herein lies the beginning of the challenge, I think. So I counted on, as the clip was playing, 6 people that were at that scene. And 6 untrained people, and I'm sure Rachel will have some comment to make on this as well. So they appeared at the scene, they wrapped the body in a rug, so there's issues potentially about cross-contamination, about introducing other evidential traces at that point. They then put the body into a car, so you've got other potential elements where cross-contamination could occur, and then they took the body back to the house, they undressed it, they washed it, they then had lunch, if I recall, and then they decided what to do next. So the initial, the early stages of scene investigation are some of the most critical. And they're ones where our job as forensic practitioners is to minimize contamination at those scenes and to take great pains to do so, to minimize how we might contaminate the scene by being there and how we protect ourselves from any hazards that might be present. And none of that was undertaken. Now, there was good practice around at this time. People law enforcement were beginning to learn their craft and their trade in terms of the importance of protecting scenes. So there was certainly a knowledge base there that could have been used at this particular scene. I think as the series of events progressed over the next few days, there was also issues about the scene. Because as you said, initially, this wasn't treated as a suspicious death. And so the body was buried at one point, and we will hear a little bit more about that later. But then, of course, it became a mystery of, well, how did this happen and what had occurred? And so we hear, as we go through the trial papers and the transcripts, of various members of staff wandering back up to where this event occurred to do a bit of sleuthing and to try to work out for themselves as what might have happened, what were the chain of events that might have occurred before the authorities came in and really started to lock it down. And there were items of evidence that were left behind that were then moved, so nobody knew where they were at those critical moments immediately after the death had occurred. So not how we would do it now, is, I think, fair to say, and not how it could have been done then, because there was, as I said, good practice, and we know that by certainly police officers in the bigger cities who were kind of learning their craft.
I think one of the most shocking bits of in terms of the scene management was that everyone and literally their children go and visit the scene of the crime, but they found a piece, I think, of a skull, and it had a couple of pellets embedded in it, and they found it, and then they sort of buried it and put a bit of turf over it. And then it was dug up again a bit later, but the pellets are gone and kind of handed around. Rachel, now you're a forensic firearms investigator, probably horrified at all of this. Nowadays, how early would you be brought in if this was a contemporary case? At what point?
Well, right at the beginning. As soon as the police are notified that there's been a shooting, then we would be notified as well to attend. There's a protocol within Police Scotland that any discharge of a firearm, they have to contact the Forensic Firearms Department. Whether we actually attend or not depends on what it is, but they have to contact us. So as soon as the police doctor would have been notified, we would have been notified. But generally these days, that's at the very beginning, before the scene has been disrupted or anything. So the police would know to keep that scene secure. So what do they say? Nothing in, nothing out.
So if this had happened today, would you expect to actually go and visit the scene yourself? Would you expect to be there early on?
Absolutely. And because there was a body there, the body was already dead when it was found. It should have been kept at the scene. Obviously, if there's still life, then the body would have to be removed to the hospital. But if the body was already dead, it needs to be left at the scene. We look at a scene as like a big jigsaw, and if the more pieces of the jigsaw that are there, the easier it is to determine what has been, what's happened. And that's kind of how we see it.
Now, it was thought to be an accident. Alex, the local GP, was told it was an accident, and he believed that. But to what extent do you think, had you been looking at this case, do you think you'd have smelt a rat if you were in his position? Are you surprised that it was just, it's an accident, no problem? Do you think they should have been asking other questions and looking for alternative explanations, even at that early stage?
I would have definitely smelt a rat, yes. But I think the police would treat this as an unexplained death at the outset and really adopt the Inspector Clouseau approach of suspecting everyone and suspecting no one and preserving the scene, as Rachel has said, because there's a lot of potential evidence that could be harvested from the scene, whether it's DNA, firearms, discharge residue. But the position of the body and the position of the weapons, if they're are all key elements of the case. So it should have been preserved and looked at very carefully from the outset.
So what happens is the local doctor initially told it was an accident. He believes that. He tells the Procurator Fiscal it's an accident. But later he changes his mind when he examines the shotguns which have been involved in the incident. It also comes to light that Monson and his wife just happened to have taken out life insurance on the victim, Hambro, just the day before he dies. Okay? Before he's even buried, Monson is trying to cash in the policy. I kid you not. Consequently, Monson is arrested and charged with murder. Scott was also charged, but as we heard from Jan, Scott, the alleged boating engineer, disappears. In fact, he disappears within hours of the death. He has his lunch first, and then he gets on a boat, heads off in the direction of Glasgow, and is never found during the course of the investigation or the trial. So although he's a key figure, he doesn't take part anymore in this story, which is a weird part of all this. Alex, I mean, from your point of view, how strong a case do you think was made for why Monson might want Hambro dead, and how important is his motive in all this?
Well, the first thing to remember is the prosecution never has to prove a motive, and the reason for that's obvious. Sometimes killings occur in the spur of the moment, or we may never discover what the true motive is. But I would always look at a homicide and ask the question, who benefits from this death? And that allows you to then look at potential candidates. In this case, as you've just illustrated, there's a financial benefit in the death to Monson. And if you look at the transcripts of the trial itself, an inordinate amount of time was taken up with the financial labyrinth of transactions, which I wonder if it caused a bit of a problem for presenting it. But you would always look at a motive, and if there is a motive, I would certainly lead evidence of that. But you have to be careful with that too, because if the jury reject that, then they may take a different view of the primary facts. I mean,
the financial case it's complicated. If you want to go and really dive into it, please go and look at the trial papers. Because there is an argument made during the course of the podcast and in the trial itself that actually, in a sense, Monson, if he did go and kill Hambro, he was killing off the goose that laid the golden egg. Do you think there's a convincing argument, Eve is nodding, that do you think they made a convincing argument, you know, that actually, why would he kill off Hambro when Hambro was his ticket to big wealth? Hambro was due to come into serious money, wasn't he?
It's really difficult to know, and as Alex said, the whole element of the part of the case that dealt with the finances was incredibly complicated, and was gone into during the trial, as far as I recall, and it became such a quagmire. It became so dense that the expert from Police Scotland that we asked to look at that herself said, "My goodness me, this is really complicated," and it then goes to, you know, what you're trying to say, Penny, really is to simplify that motive, and that part of the motive seemed to become much more complicated during the trial, which perhaps didn't play in the favour of the Crown. Why would they, if they did, do away with Cecil because he was the ticket to wealth? The question then would be, well, was he? Because we've heard that the family didn't perhaps have as much money as perhaps was thought. So there may be actually another part to that story with respect to whether there was actually any gold behind the golden goose at all.
See, this is what I love about this story, is that has never come up as a possibility while we were making it, and now you've raised that. I'm thinking, oh, there's this whole bit that we didn't cover. Maybe he had no money in the first place. Rachel, let me turn back to you. Monson's been charged with murder, okay? Hambro's body was buried and is now exhumed. I think it was about 3 weeks to a month after he died. And a post-mortem is carried out in the presence of experts for both prosecution and defence. If, again, this was to happen now, would you have a role in this in terms of the post-mortem? And in what way would you be involved?
Absolutely. We request at any crime scene or any death by fatal shooting, we request that we attend the post-mortem. It's very important, even if a scene seems to have all the answers at the crime scene, and if it's been a self-inflicted injury, and it all, like, there's letters and whatever, and we would still ask to be present at a post-mortem because they give us so much information. They can tell us what's happened at the scene. We'd just verify things that we've already seen, or witness statements, blah, blah, blah. But also if there's unknown situation like this turned out to be, it would also, we would learn a lot of things from the post-mortem.
Okay. I want you all to take your fingers and pop them on the bony bit behind your right ear. Okay? Because I want you to visualise this. At home, you need to do this too. According to the post-mortem, that is where the shot entered Hambra's head. And because of the shape and the direction of the wound, and the fact that a portion of his right ear is taken away, they conclude that he must have been shot from behind, slightly below, and in a forwards direction. Correct me if I'm wrong with this.
Agree with it. Yeah.
Okay. So the post-mortem reveals that only some of the shot entered his head. They assume the rest passed through his ear, taking off his ear, and into the surrounding vegetation. Now, that is really important, that direction, which is why I wanted you to put your fingers on there and picture that shot coming from behind there, up and forwards. Rachel, how on earth do we start to figure out how a wound like that might have been caused? What are the possibilities that we need to consider or rule out?
Well, when we attend the post-mortem, the things we're looking for are any projectiles that have been discharged into the body. We're looking at the size, the shape, the appearance of the wound. The breakage of the bone can give us an idea of where if it's an entry hole or an exit hole that we're looking at. And also deposits around the wound can give us an idea of, or deposits of unburnt powder from the actual shot can give us an idea of distances. So these are all the things that we want to be looking for when we attend a post-mortem. Again, the tract that the projectiles have taken through the body will give us an idea of where the shot has come from. And generally, those things are quite straightforward, and they do answer the questions that we have, that where the shot came from. But this case wasn't quite like that, because the wound was quite unusual, I think. Even that, I do agree with everything that they found at the post-mortem, and I think the prosecution and the defence both agreed that the shot had come from behind. And a slightly upward direction. So they had done the right things.
I mean, that's pretty much the only thing they agree on.
Yes.
Isn't it?
Yes,
that all
true.
the experts who look at this, they agree that the direction of the shot and that Hambra died from a shotgun wound to the head. After that, it's sort of all bets are off and there's a load of disagreement. From a practical point of view, then, away from the post-mortem, we've got the agreement. That's where the shot is. That's how he died. But how do you start to investigate in the lab, actually, maybe
Making the case.
Yeah, the case. Who might have pulled that shotgun trigger?
Well, it's different for every case. For a lot of firearms cases, you just have a single projectile. So the projectile, when we recover it from the body, is really important to us. Just from the size of that, so back at the lab, we would weigh it, we would measure it, we would take a visual examination of it. And just from that projectile that's recovered, we could maybe tell you the caliber, the size of the gun that was used, what type of weapon was used, which are all really important things to add and build the story. If a shotgun was used, like in this case, the shot can usually be recovered from the wound, although in this case there was only 4 pellets from a shotgun. Now, a shotgun is designed to discharge a number of pellets, so you can collect those and they give an indication of what gun has been used, and there's also wadding that comes out of the shotgun it would be important that we recovered that as well, and we can all take this backwards and see what kind of cartridge that might have come out of. And with the individual bullets, a gun imparts unique marks on a projectile. So we can look at those unique marks back at the laboratory. We have special equipment that makes a zoomy, fancy noises, and we can tell whether a certain projectile has been actually fired in a certain gun. So there are lots of things we can do with that. But this case, slightly different, because they didn't recover many projectiles from the wound. And yeah, there was nothing at the scene that was recovered. So it made it a lot more difficult.
And they did that with the wadding as well, didn't they, Rachel? Because it was...
They threw it away, didn't they?
Left at the scene, then somebody picked it up and threw it away, and then somebody else found it, and something else happened to it. So it was that sort of chaoticness at the
And wadding
scene.
and shot, like we were talking about earlier, is not, you can't actually identify it to a cartridge case, but it gives you an idea. So if there was a cartridge case found in the gun, one of the guns that had been fired, they usually have like writing on them that says this contained number 6 size shot. So if number 6 size shot is found in the wound, it's a good indication that that was one of the cartridges used. The cartridge that was, if there was a case found at the, or wadding found at the scene, from the size of it, we'd be able to tell you that it was either the 12-bore or the 20-bore gun that was used at this scene.
Had we not mentioned there were 2 different kinds of guns as well in this particular one? I mean, what actually happened was that all these experts, loads of experts, started trying to work out, I guess, where someone would have had to be standing to create the wound that was seen in the post-mortem. Fundamentally, the question that needs to be answered is, could Hambro have shot himself? Or would it have had to be someone else? I mean, that doesn't answer the question as whether it was Monson or Scott or another. But the question that needs to be asked is where would someone potentially have been standing to create that? So a lot of the focus of the evidence that's presented in court is aimed at this question, and a lot of experiments go to trying to answer this. In the case, a huge number of experts were called for. Over the course of the trial, 76 witnesses were called for the prosecution, 22 witnesses for the defence, and there were 241 productions. Let's hear a little flavour of Tom Speedy, who was an expert witness for the defence. Here he is in action.
Tom Speedy. I am a factor on the estate at Craigmillar. I have always taken a special interest in the subject of gun accidents. According to my experience, accidents with guns happen in the most inconceivable ways. I remember the case of a gentleman who was out shooting a year or two ago and who met with an accident. He felt himself falling and flung the gun from him. Accidents happen in the most unexplicable ways, and the shot, when the gun goes off accidentally, enters the body, to my knowledge, in the most unaccountable manner, by the crown of the head, the back of the neck, or the sole of the foot. The last mentioned case was one which came under my own personal knowledge. An Edinburgh gentleman let his gun fall. Both barrels went off, and one of the shots went through the sole of his foot horizontally. There was another man who I knew who shot himself in the palm of his hand, and the shot went up his arm.
So there's Tom Speedy. He's an interesting character in all this. We've only had a little bite of him, but you've got a bit of a soft spot for him, have you?
He was an interesting character. He liked to. So he was the factor at the estate, and he took as he said in his evidence, he took a particular interest in the case and he was one of those sleuths that I was talking about earlier, who went to the scene, who tried to figure out what might have happened, who undertook some experiments with guns and weapons, including shooting a gun through his wife's hair, just to see. So there was lots of very interesting, I suppose, experimentation that went on.
Alex, one thing that I was puzzled by this was, why are there experts for both the prosecution and defence? If experts are supposed to be neutral in Scotland, why is there not just one expert for a piece of evidence who says this is my expertise?
Well, the first thing to remember is that An expert witness in a criminal trial is different from a witness as to fact in the sense that the expert witness will give an opinion on primary facts and the inferences that can be drawn from it. It's not an opinion on guilt or innocence, but it's on their particular expertise. And the expert witness, or skilled witness as we sometimes refer to it in Scotland, is someone who has a recognised experience and qualifications in a particular discipline. And in court, you have to set that up and take the range of experiences, the qualifications. In fact, they may or may not have given evidence before. And it's the court that would be satisfied that the expert has the expertise. Now, in a case, it's not all that common. England, I think it's called hot tubbing, which is a rather odd, strange. But the idea is that they try and work out what the precise issue is, because their role is to educate the jury in a matter that's beyond their everyday common sense and knowledge. So it may be ballistics, it may be biology, it may be pathology, or entomology for insects, all sorts of things. But occasionally, you will, and the duty is to the court. The duty is not to the person instructing. So although a witness is called by the Crown, there's no duty to help the Crown, and likewise for the defence. But where you have competing evidence, then the jury have to untangle that, and they don't have to accept the evidence. It's like any other witness. They can accept or reject it in whole or in part. But parties are hopefully focusing their case in a way that assists the jury to reach a decision. But it can be difficult because a defence line might be, well, if the experts can't agree, how are you supposed to work this out?
Yeah, in a case like this, I mean, what did you make of this case? Because there were really differing opinions from people who are all supposed to be expert witnesses.
Yeah, well, the jury have to work their way through that. But one of the key themes of a trial, and something I always say to a jury, is that you must not look at the evidence in isolation. So you don't just look at the ballistics standing alone, because that's one aspect of it. You look at the whole fabric of all the evidence to see what might tell you about the state of mind, the conduct before and after the crime, and that can help you inform or make an informed decision on the matter. The challenge here was that there were some experts saying this gun was discharged 9 feet or more away from him, and that would certainly exclude Mr. Hambro pulling the trigger, and makes it a bit less likely that the gun could be dropped and suddenly fired.
Niamh, in this case, a lot of different individuals carried out sort of different versions of similar-ish experiments, some going completely off-piste, like Tom Speedy, but there wasn't much direct kind of repetition. There was lots of sort of single experiments. Is that significant? And if so, how so? And how important is it that there was this scattering of experiments trying to work out what went on?
I think it's as Alex said, ideally what you would want to do is gather the experts together from representing both sides, shall we say, and agree a set of experiments, and then all observe that set of experiments, and then take away from it whatever they choose. The challenge of having many experts undertaking an experiment that they believe to be the right way of testing the hypothesis of whether or not this was something that Cecil could have done to himself, or whether it was by somebody else's hand, means that you have a whole load of single experiments, essentially, trying to address the same issue, but there's no replication of those experiments. So you don't know what the particular conditions of each experimental process, what variation that in of itself brings to trying to compare the experiments together, if you see what I mean.
Yeah.
So usually if we're doing experimentation in the laboratory, we would set that up in such a way that we do the experiment over and over a number of times, so that we get an idea around what the variability of the outcome might be. And that wasn't done here, at least not in the context that we're talking about. Why does that matter? Well, it matters because each of those experts, when they're presenting their evidence in front of the public, would give their particular interpretation of a single experiment, and those interpretations may differ. So you end up with having very well-respected experts with very solid credentials all starting to disagree with each other in sometimes large ways and sometimes smaller ways. And it gets back to then, what is the jury to make of this? Because if the experts can't agree amongst themselves, then how are we supposed to believe the outcome?
I mean, presumably when an experiment, a scientific experiment is done away from this scenario, it gets peer-reviewed. There's people examine it for its robustness. But I mean, can that happen in a situation where it's an experiment that is being constructed to test a particular idea? And if so, I mean, how do you judge the robustness of science when or an experiment when it's been done for a specific case in a specific situation?
In a sense, so you can do what I would call, and others as well, ad hoc testing, case-specific tests. Sometimes you do those with materials that were recovered or that are relevant to that case, so materials found at the scene or whatever it might be. The robustness, testing the robustness of the outcome is often what the expert for the other side will do. So they will look at, what did you do? How did you do it? What were the results? And much more importantly, how, if I did experiment number 1 and Rachel was looking at what I did, then how valid is my interpretation and my evaluation of the value of that piece of evidence within the context of the case? And have I done that, in her view, as robustly and scientifically as it should be done? So there is that inbuilt part when you have experts on different sides. I think the critical thing in hot tubbing, as Alex said, is that what goes on trial isn't the science. It's the result of the test interpreted and evaluated in the context of the case. So you don't get bogged down in the jury having to really try the science. The science is the science, and it's agreed by all parties.
I'm wondering, though, Alex, how much you see it as your job to be able to look at the science and not necessarily take it as the science and be able to see how robust it is. Do you have to question this?
Well, we do, and the report's provided with the workings, so we see what has been done. The bigger challenge is conveying the information to the jury, because I'm not the expert, I'm not a ballistics expert, but if I have a case involving ballistics, I need to make sure I understand what Rachel is going to say, and more importantly, what the limits are. And we would consult, and have done, and talk about the case, understand how we present it so that the jury can understand it.
Go on. No, you're going to jump in.
Say that does happen. We have, that's why I was thinking that a lot of the evidence that was presented at this trial would have been sorted out before it actually got to the trial. So I would often receive a report from a defence examiner saying that they found something maybe different than what I found, and I would be asked to then have a look at it. As forensic scientists, we can write a report or come to opinions on the information that we're given at the time. But as the case goes on, a lot of the time the information changes. So if I'm given different information further on down the line, I will then need to reevaluate my findings, and I might come up with a slightly different answer, but that's okay, because I'm given different information. So whatever opinion I have would be on the information I was given at the time. But also, just going back to what Niamh said, it's like a lot of, we do this ad hoc kind of experimentation to suit a case, which we do, and we don't always do it repetitively. We do it once or twice to show that we're getting similar results. But a lot of the science behind what we're doing has already been done and has already been tested by the academics and things. So it's already there for us to base our findings on, if that makes sense.
And it's not unusual, particularly in complex cases like this, for the Crown witnesses to present their reports, and then as time moves on and a defence witness might be brought in, that they would write a critique, perhaps, of some of the work that was done, and that will be given to the Crown witnesses. And then there's a bit of ping-pong. It goes backwards and forwards as the scientists have that discussion, usually in reports rather than sitting down and having it. But that's not an unusual thing to have happen.
So, setting aside the Tom Speedy shooting through his wife's hair, which was a quirk, what did you make as a firearms expert who carries out these kinds of experiments to determine the kind of thing that they were trying to work out? Could Hambro have shot himself? What did you make of the experiments that they did? And do you think he could have shot himself?
There's lots of questions in there. The experiments that the pathologists and the surgeons did were all very complex and detailed experiments that I would perform myself in the laboratory. The experiments Tom Speedy did, I have no idea. We use simulants to act as body tissue and bones and things for our testing. He used the horses' heads, which is not comparable. And the testing through his hair, the reason he did that, he was trying to show that there were no deposits from the cartridge that was used. But it was all irrelevant experimentations that he did. So because there were no residues found on the body because it had been washed. So I think the experiments he did were like outlandish, not necessary, and maybe thrown in there by the defence to kind of muddy the waters a little bit. However, the other experts had done valid experimentation. Then the last question you asked me, could he have done it himself? Or could it have happened accidentally? Now, I think that when I first originally read through all the information at the beginning, I thought, no, that this is not a self-inflicted, or this has been inflicted from further away, and blah, blah, blah. But then I read that Cecil often carried his shotgun like a walking stick, muzzle up, which is the barrel ends up, loaded and cocked. So a shotgun ready to go, and he's using it as a walking stick, right? So as soon as I heard this information, I'm like, right, okay, well, that led me to think slightly differently about the case. And I actually got a shotgun from work, and I held it. I didn't load it or use it as a walking stick, but I held it kind of like the distance that we'd worked out that the shot was fired from, within the 3 feet, and I kind of held it behind me as if I was dropping it and falling. And I can't rule out that is a possibility if the trigger got caught on a branch or something like that. And so once you get this extra information, and we tried these things, I can't rule out the possibility that it didn't happen accidentally.
This is what I mean by the fact this case, you kind of lurch one way and go, he must have done it. Look, he's taken out life insurance. And then you go, oh, but Cecil walks along with his shotgun as a walking stick. And I thought they made quite a good case, the defence, for that. What did you make of it?
They absolutely did. I mean, there's no evidence, of course, that he used it as a walking stick on this occasion. And that was quite an important part.
In a case like this, I want us to get towards the verdict in a moment. But in a case like this, where you've got all these experts who are saying quite different things, and some of them, as we've heard, incredibly well respected, the inspiration for Sherlock Holmes, no less. How significant, Alex, are the communication skills of those expert witnesses? How much does that matter? Things like weird stuff like charisma rather than necessarily what they're saying, because who do we believe as a jury? I don't know.
Well, that's a good question, because some of the witnesses who gave evidence in this trial were famous people in the day, and you still see people who promote themselves in a big way. And it's not known how a jury reacts to that, but you have to look at the evidence itself and the conclusions which are drawn and compare it and contrast it with other evidence in the case. And for me, a very telling part is not just focusing on the ballistics and could he have shot himself or not, but there was evidence that this was of some distance that would exclude that. And when you have the accused taking out life insurance days before the event, and then in the immediate aftermath of the death, inquiring as to how he would get the money. When you put that as a cladding round that centre part, seems to me you've got a case.
Okay, so the poor jury have got to pick their way through an extraordinary amount of information and evidence provided by masses of experts who all disagree with each other. I want to introduce one more aspect of noise in all this, because it's not noisy enough. And I think it's significant in this case, and Niamh alluded to it earlier, and this was caused by the press coverage. Over the course of the 10-day trial, the Scotsman newspaper alone devoted an average of 20 columns a day to report proceedings, and it's estimated over 1.5 million words were telegraphed in connection with the trial.
The Glasgow Herald, Wednesday, August 30th, 1893. The unfortunate shooting fatality which occurred at Ardlamont, Kyles of Bute, is still involved in a good deal of uncertainty. No new facts have been ascertained.
Westminster Gazette, August 31st. Sensational mystery in Scotland. Suspicious death of an English lieutenant. A landed proprietor arrested. Remarkable circumstance. A great sensation has been created in the west of Scotland by the arrest of Mr. A.J. Monson, a landed proprietor there, as the result of police inquiries into the death of Mr. W.C.D. Hamborough.
The excitement regarding the case reached a climax on Wednesday afternoon when Mr. Monson, the tenant of Ardlamont, was arrested. Sheriff Shape and the representatives of the criminal authorities for the county took an extraordinary number of precognitions on Tuesday, and the substance of these was, it was alleged, sufficient to justify them in taking this important step.
With Monson arrested and charged with Hamborough's murder, the police start to search for the mysterious Scot, and the press go into a feeding frenzy.
A man and woman are reported to have arrived at the Central Hotel, Glasgow, on the evening of Friday, 11th of August. They signed their names as E. Scott and Miss Scott on separate lines and left no address. The couple then left the next morning with their destination unknown.
The police say they are confident that they will successfully find Scott. There were apparently rumours that Scott was actually a woman in disguise. This is now known to be false. Description of Scott circulated by the police on the 1st of September. Wanted, a man about 35 years of age, looks younger.
About 5 foot 10 inches in height, of sallow complexion, with small dark moustache and still grey eyes. Mr. Scott is believed to have been present at the funeral in the Isle of Wight.
For some considerable time, it's been known in London who the wanted man Scott is and who his associates are. Yet, incredible to relate, the Procurator Fiscal, it would seem, hesitates to act.
Police at Cork think a man arrested for robbing a constable might be Scott. The prisoner gave his name as Scott, and he is thought closely to resemble the missing Scott in appearance.
Niamh, how significant do you think the sheer volume of coverage of the newspapers was? And to say that, I mean, we got kind of bamboozled by it when we were trying to pull this together. We kept diving into the newspaper coverage, and so much of it was wrong. So much of it was wrong. But do you think it's significant?
An early example of fake news, perhaps.
Yeah.
And I think maybe the analogy of today is how much certain court events are reported on social media. It's a lot of noise, as you said. There's an awful lot of speculation about who did what, when, where, who was involved, etc., etc. And I suppose what it acts as is a distractant. Now, maybe Alex can answer this better than I, but back in those days, whether the jury became aware of this information, it's kind of hard to imagine that they did not, because it was all over all of the newspapers of the day. And did that have an impact or an influence? Now, today it would not, because the juries are kind of told not to look at these kind of information. But back then it was all that it was a sensational case. The case of the century it was described as.
You say today it would not, but...
That's why I'm pointing at Alex, to put me right if I'm wrong.
Well, it did occur to me, Alex, that what about something like the Rini McRae case, which, although the trial was relatively recent, obviously there's been years and years and years of newspaper coverage of this. So in my mind, I think, how could that not have had an impact? But what's your thoughts on this?
Well, the answer is we trust our juries. We instruct, or the judge instructs the jury not to make any investigations of their own. Now when they're impanelled or even balloted, they're told not to look at the internet and not to research anything to do with the case whatsoever. And we have to trust that they do that. And my own feeling is I think they do. And they then concentrate on the focusing effect of the evidence being led and follow that. And we have had cases, retrials. Nat Fraser, for example, who was tried again following a guilty verdict which was undone and resulted in a majority verdict. So I think we have to trust them. But it is a problem because there's masses of information on the internet, and if you were to put some accused name and you might find all sorts of previous conduct. But the judges are very stern with jury members and they're told not to do that, and they're told to police themselves, and that could amount to contempt of court, and jurors have gone to prison for that sort of thing.
Well, just before we hear what the actual verdict was, it would be interesting to hear from you what you think the most convincing evidence was in the case. Rachel?
Well, obviously I focused on the firearms evidence in the case, and I didn't really look too much at the financial situation and everything. And as I said, I couldn't see any evidence that would put Monson's finger on that trigger. To say that he pulled the trigger and he murdered Cecil. But there was another guy there, Scott was there, and we don't know what his involvement was. And also, we've got the idea that it could have been an accident, even if unlikely, it could have been an accident. So, yes, that's my view on the... I don't want to give the verdict away yet, but...
I think, like all good scientists, we need to evaluate all of the information as it appears to us. And I think you said it very well, Rachel, that as we went through the papers and you kind of read one lot and you think, all right, okay, they maybe didn't do the crime scene investigation terribly well, but if I look at different elements of the scientific evidence, and a lot of it was based around the ballistics, and you kind of think, well, it's kind of difficult to perhaps inflict a wound on the back of your own head with a shotgun, and so you're there with that part of your hypothesis, and then you get some more information about the nature of how Cecil used these weapons and the level of care or not that he took of them, and then that gives you more information, because exactly what you said earlier, Rachel. It gives you more information where you think, well, okay, I need to fit that data now into my hypotheses and reevaluate what the result might be. So I'm going to say on that fence, as I normally do.
I was going to say, I'm going to wrestle you off the fence in a moment.
I'm sitting beside you on the fence.
Alex, any thoughts on this before we find out the verdict?
But as I said, you have to look at the evidence as a whole. And when you do that and look at, first of all, the conduct beforehand, the financial interest, we haven't heard this, but we've heard a bit about there being 2 weapons, and there are inconsistent accounts by Monson as to which gun Hambro had, and he tells different things to different people. So you've got that might indicate dishonesty. Then you've got the financial interest, and then in the immediate aftermath of the death, an attempt to get the money. The defence in the trial played a lot of stock in the fact that actually, because Hambro hadn't reached 21, the financial benefit was never going to be there for Monson. But Monson, if he was making inquiry about getting the money, presumably didn't know that, and that's a thing. And for my part, I felt an awful lot of the trial was taken up with that unnecessarily. But overall, and given the evidence which there was of the distance that the gun had to be fired, I would personally think he was guilty.
But I think that's the interesting part of this, is you have the 2 scientists who go, we're staying in our lane of expertise, thank you very much. And the prosecutor is bringing the whole thing together. It's that beautiful orchestration. And that's how it works.
It is how it works.
But before we hear what the verdict was, Who thinks Monson was guilty?
Ooh.
Oh. Who thinks Scott was guilty?
He could be guilty as well.
Oh, who thinks they were both? They were in it together. Monson and Scott. Oh, we've got quite a lot there. Who thinks it was an accident? Hey, do you want to hear what the verdict was? Not proven.
How disappointing.
Get out! She says, sorry. Not proven. I'd love us to be able to turn it over to some of your questions. I realise that, we've skated over this enormous case. It's 500 pages. And I realise it's complicated, but it would be lovely if you've got some questions. I've got more I can ask, but I'd like to give you the opportunity. Has anyone got a question? Yes, we have. What we're going to do is we'll get a mic to you. So just hold fire until we get a mic. Just lay it down here at the front, first of all, and just make sure that everyone can hear you. If you're have been following us online, it would be lovely to get your questions too. So please do write those in the chat, and we'll have someone read them out. So don't be excluded from this. Yes, please.
Was it just money, or was there sex?
Ah.
That's
quite a perceptive question.
We were told he was very handsome and attractive.
Yeah. He was quite cute.
There was a wife.
There was a wife. She'd been sent away to Glasgow just that day. I don't think it was sent away for a long time. Sorry.
There was information.
There was some suggestion that there might have been a bit of a dalliance between
there was this,
Cecil and the wife.
Mr. and Mrs. Monson did divorce a bit further down the line. Clara, who was one of our fantastic researchers who inhabited the world of newspapers for quite a long time and did some brilliant digging around on this, I said to her, is there any evidence? Where's the evidence that they were having an affair? Was Cecil having an affair with Mrs. Monson? And she couldn't find evidence to bear that out. It seemed to be, it was a rumour amongst us as well, but we couldn't find concrete evidence for that. But it's suspicious, isn't it?
One thing to keep in mind is that the penalty in a guilty verdict was death. And you wonder how much that would affect the matter. And Defence Counsel referred to that in his speech to the jury, which he wouldn't be allowed to refer to the sentence nowadays.
OK, I'm going to flip a question back at the audience then. Now you know that the penalty for finding him guilty is death. Who would have gone with a guilty verdict? Just the one lady at the back.
But isn't that interesting? Because now that you know what that might mean, you're less content, shall we say, to say he did it, and maybe more sitting in the not proven camp.
Yeah, really interesting. 2 seconds, we'll get a mic to you. It's just so the people online can hear as well, and everybody in the room. The lady.
But your question to us was if we thought he was guilty, and we all do, but mostly. Anyway, right. But I would have said, but there was a reasonable doubt, so I would not have pronounced him guilty. And obviously that's why we have this get out in Scotland.
So how many people would have said not proven? Good number. Any more questions? Oh, loads of questions suddenly. Let's go with the gentleman right at the back. I think, is it a gentleman right at the back there? Oh, sorry, I can't see you from here. Waving. Apologies.
No, honestly, please don't be. I'm not offended. What was I going to ask now? I've got. Oh yes. So it was interesting hearing about the sort of sensationalism in the press and the rumours and the sort of false reports. This might be out with the scope of what you covered when you were looking at the case, but what was the press reaction once the verdict of non-proven came in?
I don't know.
I don't know.
It was a curious time because it was just before Christmas. I mean, literally, I think it was the 23rd of December, was it? And although Christmas was treated quite differently then, I think I got the impression, and I might be wrong, that it was almost lost in the kind of wash of then Christmas stuff and they moved on. What was interesting, and we do talk about this a little bit in the podcast, was Scott's reappearance. There's a lovely bit of a kind of postscript, which was so it was more about newspapers covering the fact that Monson was quite vocal on his opinion about what had happened, and he suddenly found Scott's diary, and he, as far as we know, had fabricated this diary himself and written it from Scott's point of view. And then Scott put his head above the parapet and went, I did not write that. That is not my diary. I'm here. And so the press sort of went running off with that kind of news story, which was, and we have that as a sort of postscript on the series. I've given it away now, haven't I? So we had lots more questions. Can we... here's a gentleman down the front here. He's got a beard.
So actually, just a follow-up on that. So once Scott was out of the woods and sort of known, was anything said, or was he questioned further about what happened?
Not that I know of.
No, because he was no longer an outlaw.
Yeah.
They took him to the police station. He went to the press, I think. I can't remember which newspaper it was off the top of my head. And they took him to, I think it was Scotland Yard in London, and they went, the trial's over. We're not after him anymore. The trial's concluded. Am I right in thinking that?
I think that's what happened.
Yeah. So he was just like
happen
that.
now.
Yeah, no.
There was also, and correct me again if I got this wrong, there was also a sort of a weird follow-up with Monson, because he was, waxwork of him was made in Madame Tussauds. And he sued them because he said, you're making me out to be a criminal. I was not found to be a criminal. And it was the first a defamation case. He won a penny, I think, was the payoff. But it was kind of this the case was almost, it just kept giving these kind of interesting, bizarre sort of outcomes of the characters that were involved in it.
Yeah, Scott appeared in, I think, some shows.
Yeah.
He played this character called the Disappearing Man. It was sort of a magic show. And he'd disappear partway through. Go figure. We had some more questions. Let's take some more questions. The check shirt. Is that someone? Check shirt. Oh, sorry, it's very difficult to see from here, but wave your hands again. Oh, lady in the black shirt.
Thank you very much. I have probably a more sober question. Taking this case to today, evaluating forensic evidence in any murder case is incredibly expensive. So I think Niam already alluded to the fact that it would have been much more structured nowadays. But would there have been a case where you would draw a line to say, this is too many productions, it's too chaotic, we can't possibly, it's not going fast enough or concrete enough, and you would draw a line and then kind of close the lid on the evidence?
No is a short answer.
Okay.
If there's a sufficiency for a murder, then it's plainly in the public interest to present it, and cost would not be a factor. I mean, we have to be reasonable about it, but we wouldn't be limited by cost or limit what we're doing in the objective of having a fair trial.
And interestingly, Liz Norledge, who was our sort of forensic on the financial side of things, who's the expert that we talked to, she felt this had been rushed to trial. Because actually he died in August and he was tried in December. Yeah. And she said, now unravelling the kind of finances of something like this could go on and on and on and take far, far longer. So, yeah, it could have been even bigger. So
I think with the firearms side of evidence, or forensic evidence in general, there is a sensible kind of approach that where some assessment is done prior to all the in detailed experiments to see how much worth they would be. I mean, ultimately, it's up to the court to decide whether they want those exams done, and they can override anyone and say, yes, we'd still want them done. But a lot of the time, if there's discussion there, you can cut out some of the experiments to say that they're not going to give you that much information as well. So that kind of keeps things a bit more sensible.
there was someone just behind you there. Let's just come to you, 2 seconds.
Thank you. Would the trial have gone ahead today without Scott?
Yes, but what happened in the case is he was declared an outlaw. It was just not what would happen nowadays. He would be indicted as the two of them because it seemed to me there's a joint case for both of them. And if he didn't turn up, a warrant would be sought for his apprehension. The prosecution would then have the choice of proceeding without Scott, and might have to do that if you can't find him, or adjourning it to try and find him if we could. But yes, it would go ahead.
We got any more questions? Yep. Let's take the gentleman down here, and then we'll whiz round to the other side.
I'm not sure what will be the question exactly, but I have some thoughts around this doubt and how this case would play out today's word, where you described it, how much better forensic science became, and how much better procedures and techniques we have. But also in the last 10, 20 years, there were lots of shows which showed unrealistic picture about what's possible at all. And I have the expectation that maybe jury would have unrealistic expectations for certainty from these evidences. So how likely that we possibly could be more decisive, even in today's world, with forensic evidence?
I think you're right. I think that there's, and it's not just TV shows, it's novels as well. We love solving...
Podcasts.
Yes, podcasts, thank you. Not ours, can I just say that one straight up? That we all love solving mysteries, and murder mysteries in particular, and can be swayed by what you see in TV shows because they're television shows. Their job is to entertain you and to give you information quickly, and forensic science isn't like that. It's rare that you get instantaneous results that will be the smoking gun, as it were, pardon the pun. And so our job as expert witnesses is to communicate the evidence that we find, the data that we get from our experiments, in a way, so to interpret that and evaluate it, to give it a value that's held within the context or the framework of circumstances of a case with the allegation that's there. And the importance of us being able to communicate that in a clear way, such that you, the triers of fact, the jury, can understand what the evidence means, can make your own decision about its importance and value or not, couldn't be more critical from that. That's part of our role. And it's a challenging one because scientists aren't always very good science communicators, for example. And so the forensic scientist, the ultimate part of our job, is, one could argue, is actually standing up and giving that evidence. That is the nub of it. That's what makes us, enables us to contribute to the whole criminal justice process. And so being good communicators and being able to understand your expectations of us, you know, as the omnipotent forensic scientist who'll tell you who did it, which isn't our job, trying to ensure that what we do impart is information that you can understand. And I think jurors take their roles very, very seriously, and are provided with guidance from the court as to say how they use our information. But the onus is upon us to communicate it in such a way that it doesn't bamboozle you and that you can
it's
make
an
decisions.
important point for us too, because we have to make sure we don't stretch the evidence beyond what is tolerable and reasonable. I bought a cartoon from the late Tony Husband, who used to draw for Private Eye on a strip yobs, and it's two yobs walking together, and one said to the other, "What's DNA?" And the other one said, "I don't know, but if you've got it, you're guilty." And I have that in my study, and I always think about that because it's important to just make sure we keep the limitation.
But sorry, go ahead, Rachel.
What I kind of think, though, is from the TV courts that you see, it's all very exciting and dramatic and stuff. And no offence to any of us here, but
it isn't.
It's not. It's very
dull.
boring. If you were to sit through a full trial like this one, it would be like, yawn material. So it's not as exciting as it's like the real life as it is. So I think that's where the jurors kind of have the difference.
But Alex, you've said to me before that in some circumstances, if DNA isn't in a trial, that you as part of your role...
Yeah, I've had cases, I can think of a particular murder case where we had a particular scenario, that the trial theory that we thought had happened, but there was a complete absence of DNA or blood or hair fibres and other things that might be expected in this particular location. And I led evidence from a scientist to explain how what I said could have happened without there being a trace, because I'm always worried about the CSI effect, that juries might think there is a scientific answer to this, but there isn't always.
No, there isn't.
Sorry, a little cough right there. That was what I was going to ask. Because interestingly, just before, when we were sitting outside, we were talking about DNA, and some of the things that we have now wouldn't necessarily have impacted on this case.
Yeah.
You're going to have to talk amongst yourselves.
Any more questions?
I'm conscious of the time. Should we take one more question? So whoever gets their hand up the fastest. Lady down here. Yes.
Did anyone benefit from Cecil's death financially in the long run?
Not in fact, no. No.
Did his dad not get the money? The life insurance money?
Don't think so. Jan said she doesn't think so, so she's the authority. I don't think so.
I thought it went to his dad. I thought it went to his dad. But maybe I'm wrong. It was about 20,000.
We'll have to look it up.
If I might need you to read this last final bit.
So I'll finish up while Penny has some more water. So really, this is just to wrap it up. We're just at 8:30. And firstly, I want to thank all of you for spending the evening with us and allowing us to talk about this absolutely fascinating case, including those online. Thank you for your attendance, and I hope you enjoyed the event as well. We have, as Penny said, created a podcast about this case that gives you lots more information about the set of events and the background that led up to this, including access to the case papers. So if you want to go, you can download some of the case papers and look at them because they're all in the public domain. The podcast series is called Inside Forensic Science. There are 3 series. This is number 3. So there are 2 others that looked at other very well-known but historic murder cases, the death of Jean Milne and also the murder of Madeleine Smith. There's a QR code. You all have little postcards on your seats, and there's a QR code at the back of that will take you to how to get to the series. We'd love to hear your thoughts, feedback on that when you do go and listen to it, and send us a note. We've got a Facebook group on Inside Forensic Science, so you can contribute there. I'd like to thank the Royal Society of Edinburgh for inviting us to take part in the Curious Festival. It's always a great experience for us to come here from the Leverhulme Research Centre for Forensic Science at Dundee University. There's lots more fantastic events still on the go, I think. Looking for Kate. Yes, Hannah says yes. So there's lots more to get involved in and for events to come to. Check out the programme. I think there's some left out at the front if you wish to do that. And finally, I think I'd like to give a huge thanks to Jan because it was her that got Ardlamont onto our list of cases. And I'd like to thank my fellow participants here and also to Penny for doing a fantastic job in leading us through the evening. Thank you and safe home.